Welcome back to SEC Roundup. I'm Nick Morgan, founder of Investor Choice Advocates Network and the host of today's episode. And I'm very pleased to welcome as our guest today, Joe Sullivan. Joe is the CEO of Ukraine Friends and president of Joe Sullivan Security. Joe, thanks for joining us.
Hey, thanks for having me on.
So the reason we're talking, and I'm really excited to have you on, is, of course, as many people will know, a recent SEC rule went effective requiring, in shorthand terms, public companies to disclose cyber breaches within a pretty short amount of time. And so we wanted to talk with you in particular, given your background. I think you're probably the most qualified person to talk about aspects of this rule and what public companies and CISOs should be thinking about. And that's because, as many people will know, you were, of course, the chief security officer at Uber, and before that at Facebook. You began your career, or at least early in your career, you were an assistant U.S. attorney in the Northern District of California in this subject matter, sort of on cyber and intellectual property issues. We're not going to get into it in this podcast. Obviously, people will know you have had some legal issues regarding your time at Uber, and those legal issues continue. Not particularly relevant here, except that I do think it makes you particularly qualified to talk about what people might be thinking as they confront cyber issues, and particularly the issue of public disclosure around those issues. So thanks again for joining us. In addition to the rule becoming effective, so this is the SEC disclosure rule, became effective in December. A couple of other things have happened that are sort of relevant to this discussion. One, there is ongoing litigation. The SEC brought a case against SolarWinds and its chief investment security officer in October. That case is being litigated as we speak. SolarWinds has indicated as recently as yesterday that it will be challenging the SEC's authority to do what it's doing to bring this case. But the case was brought before the rule was effective that we're going to talk about. So I think that's an interesting dynamic. Does the SEC need this rule? Is it better to have a rule in the case? We'll talk about SolarWinds and that issue. The other thing that recently happened is that, again, before the rule was effective, there were reports that a hacker had hacked into a company called Meridian Link, publicly traded company. Noticed that Meridian Link did not disclose the hack, and then reports are that the hacker reported its own hack to the SEC and noted that the company had not disclosed the hack. So that suggests that, you know, some hackers are smart enough to exploit the unintended consequences of SEC policies, and perhaps that is a way that this rule could be misused. So with all of that background, I know you've talked a lot about the SEC's new rule. There's a great interview with you on TechCrunch out there people should read. I wanted to ask you, because this is relevant to our audience, what do you think are some of the unintended adverse consequences that this rule may create for companies, CISOs, investors?
Well, I think we're going to figure that out in the next few weeks and months for certain. But I can tell you, I spent a lot of time talking with security executives, and there is a lot of stress and consternation about this rule becoming active now for a few different reasons. Number one, security incidents evolve quickly, and as a security leader, when you're dealing with a security incident, you always assume the worst case scenario at the beginning. So you see one laptop in your company is compromised. Do you assume that it's only one laptop, or do you assume that someone's just driven a truck through the front door of your company and you have to protect the whole place? You always assume the worst. So that's the mentality of the whole security team. It's like, we see one issue, we have to assume everything's at risk. And so we pull the fire alarms. To the rest of the company, that might seem alarmist, but it's just best practice. Now, the question is, if you start pulling all the fire alarms in this new environment where your general counsel is, or someone else is responsible, or some committee is responsible for deciding, is this something we have to tell the SEC? I don't want security leaders to stop pulling the alarm and treating everything like a worst case scenario, because it's in all of our best interest that they act that quickly and they escalate quickly. Second part of it is technical forensics are hard on these incidents. So you don't know often what's actually happened. And we've seen some companies really screw up their communication about security incident in the past, where they'll put out one statement on day 2 and they'll say, the sky is falling. And then on day 10, they'll say, never mind. But you know what? Their stock price has already been hammered, and everybody's like, they only heard the news from day 2. They didn't hear the never mind on day 10. Or you see other companies that they've said, hey, we were a little bit hacked. And then on day 4, we discovered we were a little more hacked. And then on day 8, oh, we were even more hacked. And then sometimes 3 months later, oh, we were really badly hacked. That's because of the reality of what's happening inside the incident response. It's really hard to reach conclusions on the technical side. So how do those different situations get translated, and who decides what's material? That's what's scaring the CISO, because their primary job is to stop the bleeding when the incident happens and manage it. But now they got to have half their head in the meeting handling the response, and half their head with a disclosure committee talking through materiality and the definition of that. The other part that CISOs are very scared about is that they don't get to make the decision on materiality by themselves. That decision is going to be made typically, I think, by some type of committee. Based on what I've been hearing from CISOs in public companies in particular right now, they've all been setting up these committees and figuring out who should be part of it. The security leader is not the decider in chief in those situations. And I think they're worried that what they think might be material, someone else is going to overrule. And if, say they're 3 weeks from the close of the quarter and the sales team has a bunch of contracts that are about to get done, is that sales leader going to want to announce something right now, or are they going to say, can we slow roll this? It's going to create tension between the security leader and business executives potentially, which could undermine the authority of the security leader or their voice for the long term inside their organization. So there's a lot of little tensions that are being worked out and that we're going to have to deal with as people in practice respond.
Yeah, I think you bring up a great point about the initial reaction by the security folks being the sky is falling. It seems to me, I've had lots of conversations around disclosure of lots of different kinds of issues, and materiality is always key. There seems to be a tendency in other areas to err on the side of caution. And if it's unclear whether it's material, we don't want to be accused in hindsight by the SEC, by private plaintiffs, by anyone of failing to disclose. Why not? Let's just disclose. But as you point out, if you disclose and you find out more or better information later, stock price could have been hammered, shareholders are harmed. How does that help anyone? So it's really a tough position for people to be in. Well, I encourage people to go read the TechCrunch interview with you. I think you've raised some very interesting questions, and I think we ought to revisit this issue in 6 months and talk about which SEC enforcement cases have been brought and whether they were wise. Well, thank you so much for being on, Joe, and for everyone else, we'll see you at the next SEC Roundup.
Thanks.